A Christchurch couple locked in an epic legal battle with state-owned quake insurer Southern Response says it's sobering for a Court of Appeal decision to go their way a decade on from the harrowing earthquakes. An earlier High Court decision found the state-owned insurer guilty of misleading and deceptive behaviour when it shortchanged Karl and Alison Dodds tens of thousands of dollars after their quake-damaged house was written off. The Dodds say they were tricked into accepting a lower offer from Southern Response, only to later discover the insurer had kept secret from them a second higher estimate to rebuild their damaged house. The High Court ordered Southern Response to pay the Dodds almost $180,000 in damages plus costs, but the government appealed the decision, saying it needed clarity because of the thousands of similar cases it could be liable for. Karl Dodds spoke to me just after receiving the judgment that favours him and his wife Alison.
Hey Lisa, we are extraordinarily good, as one would expect, with the news that we've just received. Almost a cathartic moment in some ways.
I bet.
And surreal. It's a whole bundle of emotions for us. And the timing of it, Lisa, is, I guess it's just a coincidence, but having the outcome in the middle of what is effectively the anniversary for the first of the earthquakes is poignant and sobering. And I think that what we and others in Christchurch have gone through has been harrowing, to say the least. And, of course, the post-traumatic effects of having to deal with Southern Response have just added to the trauma of the earthquakes. And to bring it all to a conclusion is, to say the least, brilliant from our point of view and tremendous for the other 3,000 people.
Have you been holding your breath for a few years, Karl?
We went blue about 5 years ago when we first discovered the second DRA through lack of oxygen. You know, it's been pretty tough, and my heart goes out to Ali, my wife, who has been traumatised by this whole business, and even though Southern Response don't want to acknowledge that, just as a bit of background, Ali was thrown around on the upper story of her work building from side to side, thinking her building was going to collapse, and she got a chance to glance outside the window to see the CTV building gracefully descending to the ground, and made the observation everyone's dead. And that's haunted her ever since. And so when one considers what Southern Response have put us through, which is pretty much right up there, dealing with this day in and day out, and discovering more of their chicanery as time has gone on, has been really, really destructive.
Are you worried about the prospect of a Supreme Court case?
The whole reason that we were taken to appeal was that Minister Grant Robertson needed, and we understand the logic behind this, to seek clarity on what was a slam-dunk case in the High Court. If Southern Response believe that the appeal process has not given that clarity and that they want to get further clarity on the clarity that's just been given, then that's their right to take it to Supreme Court. They would be, I believe, very foolish to so do, because two sets of the highest courts in the land have found against them. I think it's time to say enough is enough.
Yeah, so Southern Response, obviously this hopefully settles your case, but the issue about Southern Response generally and its behaviour, given what we've discovered during your case, does there need to be closer scrutiny of this body overall?
There needs to be not just closer scrutiny, but digging under every rock and every cave where some of these folks seem to be hiding, and make individuals accountable. Now, what we know, Lisa, is that the decision to withhold critical information from policyholders was not made at senior management level. It was made at a higher level than senior management. Now, that means it was either made at the executive, i.e. board level, or at ministerial level. Now, it is not for us to comment where. All we know, it was made at the highest level in the organisation. We believe that the time is now to bring in an independent consultant, perhaps somebody like Dame Sylvia Cartwright, to tear them apart and just look at exactly what they have done, how they went about it, and exactly what is the scope of their chicanery.
So, Karl, you're talking about an inquiry. Obviously, Dame Sylvia has completed an independent inquiry into EQC. You want the same for Southern Response?
Yes, with one difference. The difference is that EQC made a lot of mistakes, but they were really caught off guard. Nobody expected the magnitude of the disaster. They were understaffed, ill-equipped, and perhaps one could say they did their best, although that said, we spent the first 2 years battling EQC with letters flying backwards and forwards and getting more and more fiery as we went. But with Southern Response, they don't have the same excuse. They came into existence after the disaster and therefore were well equipped to behave professionally and competently. And this they failed to do. And indeed, when an independent person digs deep enough, they will find all sorts of additional dubious practices of which we are well aware, but we are not going to disclose at this point in time, which will really push the whole case as to their behaviour into a different level beyond that which we've done now.
What do you say to I think there's about 3,700 others who may be in similar circumstances to you in terms of their claims? What do you say to them?
We say to them, well done. They're going to receive, all being well, that to which they were entitled. That had Southern Response not decided to run a dual system of bookkeeping, they would not be in the position that they're in, and we offer and wish all of those 3,700 people all the best luck, and I hope that their case goes smoothly and swimmingly.
Karl Dodds speaking there. The appeal court reduced the damages Southern Response has to pay the Dodds by just over $10,500 due to an earlier error in calculations. The minister responsible, Grant Robertson, has declined to be interviewed. Southern Response has also declined to come on the program this evening. Neither have ruled out appealing the decision in the Supreme Court.